Hello, everyone. Welcome to this conversation on school desegregation. In this conversation, we're going to look at some introductory information on early Supreme Court cases that kind of laid the foundation for school desegregation. These cases occurred between the 1930s and 1950. Then we're going to look at the Brown decision, Brown versus Board of Education of Topeka, Kansas. We're going to look at the ruling itself, and then we're going to look at the court's decision on how to implement that ruling and what's called the go slow approach. And then we're going to look at the Southern response to the Brown decision, in particular the Southern Manifesto, and then both legal and illegal resistance to school desegregation. And then finally, we're going to look at the events in Little Rock, Arkansas in the 1950s, which kind of give us a window on how this kind of played out in different places. But obviously, Little Rock was an extreme example. And we're going to look at how Arkansas chose to defy the federal court order to integrate the school and how President Eisenhower responded. So by way of introduction, there were these early efforts by the NAACP to work on school segregation issues. So we know that the NAACP was formed to deal with issues of equal rights back in the early 1900s, and how they chose litigation primarily as their primary method. Thurgood Marshall, one of the NAACP lawyers, is going to be in the forefront of much of this, and ultimately in the 1960s become a Supreme Court justice, the first African American Supreme Court justice. The case that really begins this conversation is from the 1930s. It is Missouri ex rel Gaines versus Canada, and essentially it was a situation in which an African American, pictured here, Lloyd Gaines, was denied access to the University of Missouri Law School. And the practice at that time was that black students were given scholarships to attend school out of state because the University of Missouri was still segregated. And when this went to the court ruled that the University of Missouri must either integrate or create a separate and equal school, that Missouri cannot allow its university to do this, to practice this, to give these scholarships to go out of state. And so that's kind of the first crack in the issue of school segregation. And secondly, in 1950, there are a series of Supreme Court justices or Supreme Court rulings that deal with issues of segregation. The court struck down segregation in rail cars, and it also ordered that the government provide equal schools or integrate existing schools. So we're talking about state and local governments. It is no longer okay to have unequal schools. And that really gets to the primary issue. We know the separate but equal doctrine from all the way back in the 1890s with Plessy Ferguson, which basically laid the foundation for segregation. Well, this ruling is saying if the schools are not equal, you're going to have to integrate. It's not going all the way to school integration, but it is saying you have to make sure these schools are equal, or integrate the schools. These are your choices. So I want to begin our conversation as we think about the Brown decision on school desegregation. I want to ask the question, why integrate? Or why, after all this time of two societies, why would we integrate in the first place? And then I think a second question would be, why schools? Why would schools be on the forefront? And I think there's some really good answers to that question, but why would we integrate? What is the impetus for integration? Anne Braden, in her book The Wall Between, said, and it is true basically too, for almost invariably it is a fact that concrete steps towards social change are made by the person or the group with the hard material need. Even the most crusading of us have a tendency to vacillate and hesitate, to try to live as long as possible with the status quo, if there is nothing but abstract principle to push us on. And I think that this, Ann Braden raises a really important issue. Why integrate? Because there were people that were being denied certain things in our society that created need. There were people that were being harmed by segregation. That's why that's why people would press to integrate. And I think she makes a good point with, when you're just talking in the abstract, when it's not affecting you directly, you might be for integration, you might think it's not a bad idea, but to really press the issue, you have to have a need. And that's what's going to happen in the 1950s. Black Americans with real need, with real issues of discrimination, things that are causing them to be held back from being able to experience all of what America has to offer, are going to say, enough is enough. We want this, and we're going to press for this. So that comes to fruition in part in the Brown decision. So in Kansas, the Brown versus Board of Education of Topeka, Kansas, 1954, the Supreme Court looked at a case in which Oliver Brown had petitioned the court to allow his daughter Linda to attend a local public school that was in walking distance of their house. So you have a little girl. Her dad wants her to be able to go to the school that's close to the home that she can walk to. This is a black family. The school is white. The school won't allow them in. And so this is the issue of material need, of something that's affecting a person's life in a negative way, and they're going to say, I don't accept this. I would like the government to step in and allow my daughter to attend this school. So the Supreme Court looked at this case, and in 1954 they ruled that public education is a right which must be made available to all Americans on equal terms, and that separate schools generate a feeling of inferiority. And I think that's really important to think about. The court said that the act of separating schools makes a statement. It is saying something about the groups. And why would you separate people into different schools by their skin color and not their eye color or their height or their weight? Well, why would you do that? Why would you pick this out? It's because of the underlying things that we've talked about. It's because you think these people are different from the rest of society. And so you make this choice to separate. And so the Supreme Court said very accurately, it creates a feeling of inferiority. And then they said, so separate schools are inherently unequal and deny students the equal protection of the law. And I think the really important and compelling point here is that we know that in our world, we separate people for different reasons educationally. We don't put high school seniors and first graders in the same classroom. Why do we separate them? We separate them because we don't think we can give them an equal education. We have to meet them at their place in life. So the Supreme Court is saying, you can't apply that same thinking to a black senior and a white senior. That is inherently unequal. That generates a feeling of inferiority. You can't separate people educationally by race, because inevitably you're going to end up with, if that's what the basis of the separation is, you're going to inevitably end up with unequal education. So I want to say that again so you catch that. If the basis of separation is that you think these groups are unequal, then the schools, without question, are going to be unequal. The separate schools will be unequal. And that's what the Brown decision addressed. And that's really why education becomes the foundation of the movement of integration. That's why it starts with education. Now, the initial reaction to Brown was actually very positive. By the way, you see in this picture, Thurgood Marshall is in the middle of this picture. Uh, we really see the hope of a multiracial society the way it really should be. And that's because border states, the northern part of the South, the upper South, very quickly began to integrate, and there were almost no incidents, almost no problems. People had kind of seen this coming in lots of different parts of the country and thought ultimately this is going to change. And so the upper South kind of adjusted itself pretty quickly to the new regulations, to the demand for integration. And so there's a lot of hopefulness in this moment. One of the big drawbacks, though, is that the next year in 1955, the Supreme Court made its decision on how integration would actually occur. And so um, this is the process that the Supreme Court put in place that we call the go slow approach. They said the responsibility for integration plans are in the hands of local authorities. So your local school was required or told by the court that they needed to make a plan for integration. The enforcement of those plans of integration was given to federal judges in these local areas. So the federal government enforced it, the local community made the plan. And that's fine, but where this breaks down is that they said, as far as timeline goes, they didn't create a specific timeline. They said that you have to have a prompt and reasonable start to integration, and you have to complete it with all deliberate speed. So notice the very vague language, and just by example, they could have said, this is 1955, this is written, they could have said, you must complete this in 3 years. That would have been a fairly reasonable timetable. They could have said you have to complete this by next year. They didn't say that. They said prompt and reasonable start with all deliberate speed. And so what exactly does that mean? That's a problematic thing. And if you look at this map, it really, really is helpful to understand what happens. So up here in these border states, or the northern states that I just talked about a minute ago, look at how much integration occurred in the first 10 years. Look at 28% is integrated in Oklahoma, Missouri's 42%, Kentucky 50, more than 50%, West Virginia more than 50%. That's pretty significant, and that's because of what we talked about early on. Notice these states, Tennessee, Virginia, and Tennessee, Virginia, and Texas, and Florida, we're talking 1, 2, 3, 5% integration in the first 10 years. And then look at these deep South states, and there's almost no integration. Look at Mississippi after 10 years, no integration whatsoever, or less than 1% of people are going to integrated schools. And so obviously, this go slow approach um, ended up to be a go very slow approach. And that's a reality that we need to come to terms with and understand. And again, this map is a map that looks at the first 10 years of desegregation in Southern schools. So as we move to the Southern response to integration, and as we saw from that map, obviously there's going to be significant resistance. So ask the question, why would people resist integration? There's got to be a reason. There's got to be probably a very good reason to resist integration. Why would white Southerners resist? Esau McCaulley, in his book Reading While Black, said, according to Isaiah, true practice of religion ought to result in concrete change, the breaking of yokes. He does not mean the occasional private act of liberation, but to break the chains of injustice. What could this mean other than a transformation of the structures of societies that trap people in hopelessness? Jesus has in mind the creation of a different type of world. So I picked this quote to illustrate something that is really an answer to this question, why resist integration? The reason white Southerners are going to resist integration is that integration is really the creation of a different type of world. They created the segregation system for a set of deeply held reasons and beliefs. They thought that was the right thing to do. They thought it was the best thing to do, especially for themselves. So integration is not an occasional private act of liberation. It's transformation of the structure of society. And it is the creation of a different type of world. And what Macaulay is saying is that's where the Bible is. That's where Jesus is. That's the conversation Jesus is having. The South wants to have nothing to do with this conversation. They don't want a different type of world to be created. And so they are going to resist, and they're going to resist aggressively. So the Southern response really begins with what is known as the Southern Manifesto, which was written and signed by 101 Southern members of Congress in 1956. And what those Southern members of Congress said in what they called their Declaration of Constitutional Principles was that the court had no power over education whatsoever. Um, the states and the parents have the power, and the states have the right to legally oppose integration. So you have 101 members of the United States Congress essentially saying that the South doesn't have to follow these new federal guidelines. One of the big proponents of that was Democrat Strom Thurmond, who's pictured here. In the process of writing the Southern Manifesto and reviewing it, you should know that Thurmond was a Democrat at this time, but as many Democrats did, Southern Democrats did, whenever the civil rights movement got going full blown, many of them in this process of the next 20 years, when the Democratic Party chose to come down on the side of civil rights, many of these Southern Democrats became Republicans, and Strom Thurmond ended up having a long career later as a Republican in the United States Senate. So the Southern Manifesto says this is a state issue, it's a states' rights issue. It's kind of a lost cause argument if you think back to that. The states and the parents have the power, the federal government has no power or right to be involved in this conversation. So there's a vast legal resistance put in place by Southern communities to resist integration. It included stalling. So if you think of the process, one of the ways to resist the process is just to stall and force people to bring individual lawsuits. If there's no timetable, and if the local community just doesn't make a plan, then somebody has to initiate a lawsuit. Often those lawsuits were initiated with the assistance of the NAACP. And so, but that's a very, very slow process. There are also in the South more than 450 laws and resolutions passed to try to govern segregated schools and try to deal with within the law of ways to obstruct this process. Probably the most successful were what we call the pupil placement laws. So the pupil placement laws basically said, and they're passed in many communities throughout the South. They basically said that a person has a right to place their child um, in the school of their choice, and that they should not be denied that by their race. Now, that's kind of interesting because that sounds really good on the surface, doesn't it? It sounds like we're headed in the right direction here. But what they did, and something that we have to understand is the system, when we say there's systemic racism, we're basically saying our system involves two pieces. We have the laws that make up our system, but we also have the people who administer the laws. So the laws can be changed from saying schools have to be segregated to saying schools have to be integrated. But you can also corrupt the administration of the law. And that's what we're talking about here. So these pupil placement laws said you can place your child in any school, but they gave local school districts the right to decide, not on the basis of race, but on the basis of, say, morality or uh, the best the best interest of the school in general, as far as community of people that get along with each other and can learn together and can cooperate with each other. So there's all kinds of little derivatives in these pupil placement laws that allow the system to be corrupted, to keep black students out of white schools without saying we don't want to have black students in white schools. And so this is a legal form of resistance, corrupting the system itself, trying to work within the laws that exist, but then corrupting the system itself. But also, enormous activity in harassment of the NAACP, revoking its licenses in different states, bringing lawsuits against the NAACP for accusing them of, I believe it's called barity, which is bringing nuisance lawsuits. And so they tried to tie the NAACP up in court. They tried to slow them down and harass them any way they could. And then the other element of this, which is really striking, um, there were, in response to integration, 165 segregation academies founded between 1954 and 1976. And in that period, what we have is white Southerners in communities saying, we're going to found our own school and it's going to be private. And none of this applies to a private school. It only applies to public schools, to government run schools. So we'll have a private school. Many of these schools were church founded schools, Christian schools. Not all of them, but many of them. And the reason I gave the time frame of 54 to 76 is because in 76, a Supreme Court case, Munyon versus McCrary, said that private schools have to also accept black students. So it's not till 76 that private schools are under the same restrictions or advancement of integration policies that public schools are under. There's also illegal Southern resistance. Um, Notice this very disturbing picture of the child uh, with the KKK garb on and the sign, Southern whites are the Negro's best friends, but no integration. This is often a line taken by Southern whites that they love Black Americans and they're kind to them and good to them. We just don't think it's good for them or us to integrate. And we've seen that argument made from many different angles. So the illegal Southern resistance, though, goes way beyond that kindness, to be honest. And so you have mobs showing up, creating what comes to be known as gauntlets of hate, which tried to keep black students from entering schools. Uh, there's threats made against white teachers who are teaching black students. The KKK and other groups are involved in all of this. And there's also, as we know, this continued intimidation of any blacks who try to go against the system or rise up or claim their rights. And basically, this illegal Southern resistance is, let's just defy the Brown decision. Let's just refuse to go along. It's based in racist orthodoxy, intimidation, and it is in itself a form of insurrection, but it's also a response to what they felt was sort of an insurrection against them. And so the radicalism of all of this still playing its way out in the 1950s and 60s with the illegal Southern resistance. So as we think about the events of Little Rock and taking a look at what happened in Little Rock, where the government is going to use federal troops to ultimately integrate Little Rock High School. The federal government is going to use troops. My question to think about is, it is an amazing occurrence that occurred in this time with regard to the federal involvement, and why would we? Why would the federal government choose to use troops, and why would we have to get to that level of military force being used? I just think we need to really pause and consider the fact that to get black students into schools with white students, we had to use military force to accomplish that. I think that is one of the things that, if you know just a few things about our racial history, that's one that you need to know. And that's, in my parents' lifetime, that occurred. Shortly before I was born, this occurred. So why did we have to get to that point? Dwight Eisenhower, after the Brown decision in 1954, said to Chief Justice Earl Warren, law and force cannot change a man's heart. He actually said this on different occasions, something similar to this. Law and force can't change a man's heart, and he believed strongly in that. Dwight Eisenhower wasn't a president who was saying, let's get the government in here and make this happen. He said, people's hearts are not going to be changed by laws. And so, one of the reasons why we're going to end up having force used, oddly enough, is because of people's hearts, because of the depravity in people's hearts with regard to prejudice and racial bias. And then, interestingly, afterwards, after Little Rock and Dwight Eisenhower takes uses government force to bring about integration in the schools, he says this at a news conference: I believe that the United States as a government, if it's going to be true to its own founding documents, does have the job of working toward that time when there is no discrimination made on such inconsequential reason as race, color, or religion. And so later on, you see growth in Eisenhower. You see this transition in his thinking to the government should be involved in this process. And that's very, very interesting. And so let's look at the facts here of what happened. So in Little Rock, we have a situation in which a moderate school board chose to comply with a federal court order. The process occurred as normal, and to integrate their school, and they agreed to admit 9 black students to Little Rock High School. In this picture, you can see Elizabeth Eckford walking towards the school with a mob of people screaming at her, the woman right behind her. This is just a chilling thing, but when these 9 black students entered, for some reason there's miscommunication, and this one black girl, Elizabeth Eckford, ended up not with the others and walking by herself, and people surrounded her and just screamed at her as she tried to enter the school. Governor Orville Faubus, the governor of Arkansas, called out the National Guard to protect the students so that they could enter. But ultimately, this mob of people and the National Guard were combined to prohibit the students from entering the building, and the students were denied entrance to the school. So what happened was Eisenhower and the federal government end up getting involved. And in this picture, you can see U.S. military forces escorting students into the school. Now, as you know, Eisenhower said laws don't change hearts and minds. He had no interest in involvement whatsoever in 1954. He felt like Brown was a mistake. It was a bad ruling. And he supported the rights of states to figure these questions out. He was a super go slow approach mentality. He had a super go slow approach mentality. Just let the states figure this out for themselves. He did want a good result in the end, but he didn't think laws and force would accomplish that. But when Orville Faubus chose to withdraw the National Guard, Mobs surrounded the building. So he met with Orville Faubus and he said, you can't use the guard to keep them out. And so Faubus withdrew the guard and mobs surrounded the building and denied access to the students. And as a result of that, Eisenhower mobilized the or federalized the Arkansas National Guard, and he brought them into federal service. And then he did something fascinating. He sent 1,000 paratroopers. These are the guys that drop out of the sky into Arkansas to work with the Arkansas National Guard to allow nine black students to enter Little Rock High School. This all occurs in the fall of 1957. And it is just a fascinating thing to me that I guess this is what you get when your president's a general and he feels like a state is defying federal law, because that for Eisenhower that changed everything. Whether the law was good or bad was not the issue. Whether what the best idea of how to deal with this is the issue. Once a state decides to deny federal law or defy federal law, Eisenhower has to execute federal law. That's his job. And so he responded with troops. And so for the rest of the year, armed guards escorted these nine black students around Little Rock High School. Again, sobering to think about. Then in the next year, 1958-59 school year, Governor Orville Faubus ordered all schools closed. And he did that because of the general feeling in the state of Arkansas that it was better that kids didn't go to school at all than if they would go together, go to school, uh, black and white students together. Faubus is an interesting case because he was actually a moderate initially, but as he got swept into this, he clearly read the popular opinion, and he decided that being a segregationist rather than a moderate was a better political plan for him. He ultimately becomes somewhat of a folk hero in Arkansas and is elected multiple times as governor following this because of the strong stance he took by closing the schools. So this series of events kind of leads us towards some positive growth on the federal level. In 1957, there's a Civil Rights Act passed by Congress. And again, oddly enough, you have Eisenhower involved in this. You see this picture with Eisenhower and other leaders. Civil Rights Act of 1957 said that authorized court injunctions against interference with the right to vote. It created a commission on civil rights. And then the Civil Rights Act of 1960 created federal referees to deal with voting issues or obstruction to voting issues. And then also very importantly for our conversation here, said that obstructing court orders was a federal offense. And so now you're bringing more accountability to those local communities who are not abiding by the federal court orders to integrate. So this isn't a gigantic leap forward, but it is the beginning of federal legislation to try to deal with these issues. There's going to be much more significant legislation coming in the 1960s. So in this conversation on school desegregation, we have looked at those Supreme Court cases that kind of laid the foundation for school desegregation. We looked at the Brown decision, the initial ruling, and the basis of it, and then that choice for an implementation plan that embraced a go slow approach with that vague language that said things like with all deliberate speed. And then the Southern response, the congressmen who came together to say this is a state issue, not a federal issue in the Southern Manifesto, and then both the legal and illegal resistance to the laws and the drasticness of that, in particular, with 165 private schools being established so that white children could go to school separate from black children, and the fact that those schools were overwhelmingly church-based or Christian schools. And then we saw the events of Little Rock and the choice of Arkansas to defy a federal court order and to allow people to obstruct these 9 students from entering school. And then ultimately the federal response led by President Eisenhower, and then the closing of the schools by Governor Faubus. Some takeaways from our conversation. Thurgood Marshall and the NAACP pursued a vigorous litigation strategy against school segregation that resulted in the court ruling stating that separate schools are inherently unequal and deny blacks equal protection of the laws. Southerners pursued an aggressive legal and illegal resistance campaign to integration, claiming the court had no right to rule over education, which was a matter for states and parents. The governor of Arkansas defied the court ruling, resulting in President Eisenhower responding by sending federal troops to enroll black students in Central High School, and Little Rock responded to forced integration by closing its public schools. Some questions to consider. Do you agree with the court's ruling that separate schools create a feeling of inferiority and are inherently unequal? Why or why not? Do you agree with the argument of the Southern Manifesto that education is a matter for states and parents, not the national government? Why or why not? What would be a biblical view of that? Then thirdly, what are the moral implications of Christian segregation academies? And then last, do you agree with Eisenhower's use of federal troops to admit black students to school? Why or why not? What are the implications, again, from a Christian perspective of the federal government being involved in a question like this? Thanks for joining the conversation today. God bless you and have a great day.